Be ready for the dictation. The dictation will start after 5 seconds. Equality of opportunity pitted against reparations for long years of deprivation of equality has been the subject of judicial discourse while adjudicating affirmative action introduced both by the central and state governments within this country. One of such affirmative action exceeding the 50% limit as prescribed by a 9-judge constitution bench in Indira Sani versus Union of India 1992, enhancing reservation to 65% within the state of Bihar, is challenged in these batch of writ petitions. The state has brought in such reservation based on the caste survey, which found the majority of the population within the state belonging to the marginalized and deprived communities. The petitioners' cry fall on the perceived sacrifice of merit, thus frustrating the fundamental right of equality of opportunity in public employment and admissions to educational institutions guaranteed under Part 3 of the Constitution of India. Learned Senior Counsel led the arguments for the petitioners, which commenced with the statement that the entire edifice of the Amendment Act and the enhancement in reservation is built upon the caste survey, the results of which were published just a few days before the amendment bill was introduced in the legislature. The caste survey notified on 6/6/2022 was completed by 5/8/2023 and the report published on 2/10/2023. The caste-wise socio-economic report was brought out on 7/11/2023 and the bill was tabled on 9/11/2023. There was hence no analysis carried out despite the preamble of the Act referring to such an analysis. The atomic escalation of the percentage of each and every caste referred to in the Bihar reservation of vacancies in posts and services for scheduled castes, scheduled tribes, and other backward classes Act 1991 was mechanically carried out without reference to the real facts and figures coming out of the caste survey. It is specifically argued that though land holding of every individual was one of the terms of reference in the caste survey, there was no analysis of the economic status of each community granted reservation based on the details of the land holdings collected in the survey or an examination of the productive nature of such holding. The preamble was read over to us, which, according to the learned senior counsel, speaks of a proportional representation having been attempted, as is the provision of reservation in elections to local bodies. It is pointed out that such proportional representation confined to SC and ST as coming out from 243D and 243T based on Article 332 cannot be imported automatically into Article 16. Article 16(4) especially speaks of adequate representation as the yardstick to determine the benchmark for providing reservation in appointments in posts to any backward class of citizens, though the word adequate is not employed in Article 15(4). The Honorable Supreme Court has held it to be a valid basis for understanding the social and educational standards of backward class of citizens and of the SC and ST. The economic criteria hence is an important index on which the percentage reservation has to be considered, which has been totally ignored while bringing out the present amendment. The words of Dr. B. R. Ambedkar as extracted in para 104 was specially read out and reliance was placed on para 109 to emphasize that adequate representation does not mean proportionate representation. Para 810 of Indra Sani Supra was emphatically pointed out as the only circumstance in which there could be more than 50% reservation which is not available in the present case.